this is a very, very common sense measure here. This is a very common sense measure. This isn't a radical measure. This isn't a measure about criminal justice reform. This isn't about more resources or less resources. This is about a constitutional amendment that simply allows judges to take into consideration dangerousness. That's it, dangerousness. Now, Senator Taylor, whether it's a commissioner or a circuit court judge, we can dance around the idea of dangerousness, but I've been before a lot of judges, a lot of court commissioners that say, I am bound to follow the law, which I respect. I'm bound to follow the Constitution, which I respect. And being bound to those documents, I cannot consider dangerousness of an offender. And there's nothing more I can say. I can go blue in the face. I can go red in the face about all the dangerous elements for somebody who's abused children and grandchildren, or a domestic offender who continues to get out and repeatedly hurt folks. But currently, right now, as it's set, there's no way, there's no mechanism for a judge or a court commissioner to consider dangerousness of an offender. And that's all this, from what I can tell, that's all this constitutional amendment proposes. So as a practitioner with 17 years of experience, I strongly urge you all to consider this. This is not a political issue in my mind. It's a Wisconsin issue in my mind about allowing judges to do their job and to consider what our next door neighbor would say we all should be considering to begin with.